third case on the docket for Tuesday, March 29th, 2022 is appeal number 124587 in the matter of Michael P. Jahn, original action and attorney discipline. No briefs filed.
Council, would you please come to the lectern and state your appearances?
Chief Justice Lukert, members of the, or justices, Kathleen Selsler-Lippert, Deputy Disciplinary Administrator on behalf of petitioner, present and ready for argument.
May it please the court, Arthur Chaikin, law firm Kenny Hertz Perry, here on behalf of respondent.
Council. Lippert, when you are settled and ready, you may begin your argument.
Request permission for 3 minutes.
3 minutes granted.
Nature of the case in re Michael Jahn is an original action involving attorney discipline. The case before you today represents an agreement by the parties to present to you pursuant to Rule 223, a summary submission. The case before you represents an agreement by the parties that the respondent violated professional rules of conduct. This case stems from the respondent's representation of his fiancée. The respondent's fiancée was a teacher in a private school in Nebraska. The school did not extend an additional year contract. She believed it was based on discrimination and asked her fiancé, the respondent, to represent her in that matter. The parties have agreed the respondent's conduct in that representation of his fiancée violated rules of professional conduct, Rule 1.2 scope, 1.7 A2, substantial risk of representation that will be materially limited by the lawyer's personal interest, 4.1, false statement of material facts, 4.2, communication with the represented party, 8.4C, conduct involving dishonesty, fraud, deceit, or misrepresentation, 8.4D, conduct prejudicial to administration of justice. The parties.
I'm sorry, before you get too far into the facts, I did have one question on the agreement. Under the rule for the submission of these agreements, I don't see the aggravating and mitigating circumstances. So I was hoping that you might identify what you think those should be as you're talking about the facts, or now whatever is more convenient to your presentation.
Yes, Justice Wall. This summary submission was submitted in September, just shortly before the Rule 223 was modified to incorporate that requirement of aggravating and mitigating circumstances. And the parties do have an agreement that we are prepared to discuss with the court today. Specifically with respect to that, the parties agree and ask this court to accept the agreement that the aggravating factors in this case are prior discipline and multiple offenses. The parties agree and stipulate that the mitigating factors applicable to this case are the respondent's personal and emotional problems that contributed to the violations, his attitude of cooperation and remorse. The respondent was originally licensed in 1997, but he was not in practice or did not have an active valid license for 14 years. So the length of practice really doesn't neatly fall into either aggravating or mitigating. It's just because he didn't have a license for 14 years. Based on the stipulations and the agreements, the parties are asking this court to consider or impose a 6-month suspension, which is commensurate with the ABA standards. The parties are asking this court to that the first 3 months of the suspension be implemented, that the second 3 months be stayed, and that the respondent be placed on 1-year probation with terms and conditions, including that the respondent participate in KLAP monitoring, the respondent participate in the KLAP law practice management program, that the respondent have a peer mentor and also a KLAP practice monitor. The respondent or the the goal or the purpose for the suggesting this probation is the respondent, as noted, was out of practice for about 14 years. And his time in practice was essentially working for Social Security Administration as I think, an opinion writer. He has not previously been in private practice, and he anticipates going into private practice. The hope and the goal and the purpose of this probation plan, once a suspension is, the second half of the suspension is stayed, is to give him tools to be successful, to practice within the bounds of the professional rules of conduct that every attorney is expected to practice in. So that is the goal of the probation after a term, after he serves a term of suspension. The parties present this as an agreed stipulation to facts, rule violations, and sanctions, and ask this court to adopt and incorporate the sanctions as presented by the parties.
Can I ask a question about some of the factual underpinnings on the violations on 4.1A? It appears to me that one of the facts that has been proposed to support that violation is the fact that there was a request for attorney fees, but the representation was pro bono. And my understanding from the case law is that under federal discrimination statutes, a prevailing party can recover fees even in a pro bono situation. So with that being the case, in light of that case law, why does that fact support the violation?
In this particular situation, the demand letter that the respondent wrote and tendered to the school president on May 15th, the statement to that school president said attorney fees to date are, and the number that he provided in his letter as attorney fees that have already been incurred or involved was $25,666. So that is the statement that the respondent made to the president of the school, knowing or having in writing the retainer agreement, where he says, I think that retainer agreement is about 14 different paragraphs long, and I think pro bono is listed in about 11 of those paragraphs.
Right, but there's no factual basis to say that the amount of the fees didn't reflect the work that he put into that date, or did it? Are you saying that number was inaccurate? Let's say, forget there's a pro bono. If this was just an ordinary hourly engagement, was the number that was provided inaccurate?
As part of the case development, the respondent was asked to provide documentation of his hours or time put into this. The respondent was able to provide some calendar entries for some hours. I would describe it as sort of polka dotted around the calendar. The respondent also very clearly said he didn't keep track of his time because he knew it was going to be pro bono and didn't intend to charge anything, so he didn't really keep track of his time.
And then the only other question I had on the facts are the request for opposing counsel to reconsider the disciplinary complaint. That's a fact as a factual basis for 8.4, I believe. Is there a time when it's appropriate for an attorney to engage in that sort of dialogue with a complaining party?
I would submit to you that the answer to that is no. And that is the underpinnings of the prejudicial to the administration of justice. The disciplinary administrator's office is tasked with receiving complaints from whoever might have a complaint against a licensed attorney, investigating those and then pursuing based on the investigation and what evidence is available in a case. Even if the complaint is withdrawn our duties as investigators and self-regulating profession are to continue and to make that determination based on the facts of the investigation. There are a couple of cases with respect to that issue. So for instance, in Repile 278, Can 230, 2004, that case stands for many different things. Among them is that in that case, the respondent wrote a threatening letter to file a disciplinary complaint in order to gain leverage in a civil case that he was involved in. And the court talked about, and there are other cases where this court has held that threatening to file a disciplinary complaint is a violation or adverse to the administration of justice. Likewise, because attorneys have a duty and responsibility under 8.3 to report misconduct. And so with that duty, trying to convince somebody not to fulfill that duty is adverse to the administration.
But what if they're right? What if, I'm not saying in this case, but hypothetically, if an opposing counsel files a complaint and misunderstood the factual basis that led him or her to do so, why can't the respondent reach out and clarify the facts that may have led to the report to begin with, especially if your office is going to investigate whether or not that's been withdrawn, whether or not the complaining party has withdrawn the complaint?
The conduct of asking to withdraw the complaint doesn't alleviate, as you pointed out, our duty and responsibility to investigate, but it is putting up that or attempting to put up that barrier to withdraw and eliminate that. This court does have, there are cases in this court where respondents have conditioned maybe a settlement or returning attorney fees or some other type of settlement on withdrawing a complaint, which has also been held by this court to be adverse to the administration of justice. I believe one of those cases is the Kenny case, 289, Kansas 851, 2009. Some cases from other jurisdictions have talked about that prejudice under Rule 8.4D is measured in relation to the administration of justice, not any particular outcome of the parties. And that would be In re Ramirez, which is an Indiana case, 853 Northeast 2nd, 121, a 2006 case. So the duty to report, the duty to investigate, it's a self-regulating profession. And that duty to respond to a complaint, that assuming that a complaint is meritless, because people complain for good reasons, they complain for bad reasons, they complain for no reason at all, which is the point of an investigation. Also, the built-in safeguards and due process with respect to the review committee and the different layers of review. That is the opportunity for a respondent to put forth why a complaint is meritless, not asking the complainant to drop it. It is absolutely gut-wrenching to get that gray letter from the disciplinary administrator's office that a complaint has been received or being investigated. But your duty and responsibility under the rules is to respond to the disciplinary administrator's office that that complaint is meritless, and here's how and here's why.
Thank you.
May it please the court. Of course, we join with the disciplinary administrator in asking the court to abstain or accept the disciplinary administrator's recommendation.
I interrupt. I'm sorry. I know you had to move the mic away. Could you move the neck of it back
Yes,
and speak more into it? Thank you.
right. Let me start over, Your Honor.
Thank you.
My name is Arthur Chaikin. I'm very happy to be here before the court today on this very serious matter. As I said, we've stipulated to this summary disposition, and therefore my role at this point is to generally support the summary disposition, or at least nothing more severe than what's set out in the summary disposition. I do think that the court has raised some questions about what I would call some of the additional elements that are in the summary disposition, because this is essentially a Rule 4.2 case. It's because of the Rule 4.2 case that matter that the complaint by Attorney Flood in Nebraska was presented. And that is really the gravamen of this matter. A lot of the other elements, again, it's a stipulation. We're not running away from any of them, but one could say that they were added on to or grew out of the issue that was the Rule 4.2 problem. I would like to point out a few my opposing counsel, and it's a little odd to say opposing because we're sort of on the same side here, but Ms. Lippert commented on the issue of mitigation, which I think is a very important element in this case. Although Mr. Jahn was admitted to the bar of the state of Kansas in 1997, he did not go into the practice of law immediately. For several years, he did not practice law. He did other work generally unrelated to the law. It wasn't until about 2002 or 2003 that he began to work at the Social Security Administration. And he did work there for about 15 or 16 years. That experience, I think it's important to recognize, was not the private practice of law. And although I've worked in a lot of different elements of the legal world in a lot of different contexts, and it's certainly enriched my career, I know that there are a lot of important differences between being a law professor, which is something I've done, being an in-house counsel, which is something that I've done, and being engaged in the private practice of law. It's not that the private practice of law is necessarily more difficult or challenging than other types of practice that one might engage in, but it is true that there are elements of that practice that require mentorship, experience, and a certain degree of resilience that has to be built up over a period of time. I consider myself very fortunate in that when I came out of law school, I joined a firm. And I was surrounded by people who were very anxious to teach me what it meant to be a lawyer and how to operate as a lawyer. And honestly, I've had those people throughout my career. And as I've gotten older, I've tried where plausible, where appropriate, to play that same role. Mr. Jahn has never had that kind of mentorship in the private practice of law, never. He went from being admitted into practice in 1997 to going to only doing something legal related, law related, when he got to the Social Security Administration. He was there for right up until 2019 when he had his Kansas license reinstated, and he had not been practicing law at all when he went up to Nebraska in 2019. He was contemplating practicing law, but not in the field that is the subject of this case.
Counsel, can I
Yes.
just, sorry to interrupt,
No,
but
it's okay, you're.
in terms of the aggravating and mitigating circumstances in this case, do you agree with opposing counsel as to that there is a stipulation, or at least verbally or orally today, as to the 2 aggravating circumstances and 3 mitigating circumstances she identified during her argument?
Yes, Your Honor, we do. The record is accurate. However, I think it's important to contextualize it, because although I agree with Attorney Lippert that these are aggravating circumstances, it's not a bimodal element of, let's add up the baskets and see who's ahead at the end of the game. There are some of these elements that, although aggravating, when viewed in context, are understandable. So, for example, the multiple offenses is a mitigating circumstance. But as you pointed out, Judge Wall, some of those elements, like the concern about accuracy in some of the statements that were contained in some of the documents that were provided as part of the investigation, in context, those misstatements were not impactful or deceiving. One could argue they were deceptive from the point of view of the disciplinary administrator's office, in that they were not accurate when made. A great example of this is the one you raised, that, at the time, he wrote to Scott Catholic School and said, here's what my fees are. He was basing that on a computation of an imaginary damage claim and a contingent fee based thereon. So from the point of view of his conversation with his clients' understanding of what he was doing, and certainly from his perspective in terms of what he was presenting as sort of an opening effort to set out a position. And as you all know, a lot of times in a first go around, an attorney will set an aggressive first offer. That's really what he was doing. In terms of the hours he had in, if you want to look at it that way, in the case at that point in time, it had the potential to appear to be inaccurate and deceptive. Another example of that is, and it's in the record, Mr. Jahn wrote an agreement with his client because he was actually concerned about this representation. It was not his chosen field. He had some reluctance about it, but he was trying to find a way in his limited experience to put some limits on the representation. So he wrote, like a lot of us do, he attempted to write a limited representation agreement. And in that agreement, he said that this would be a pro bono matter. He also said that he was admitted in the federal district court for the District of Nebraska. At the time he wrote that, that was not true. And it had the potential for your run-of-the-mill client for that to be deceptive. But his fiance knew exactly what his status was with regard to the federal district court for the District of Nebraska. So taken in context, although one could say that this was a problematical issue with regard to the investigation and to the overall package of information provided to the disciplinary administrator, it really was information that had the potential to be deceptive, but in context, it really was not.
Why was it put in? Why was it put in the retainer
That he would be,
agreement? The
yes.
specific information that was false about holding a license.
I think my client was trying to be extra careful to assure that he was making a record that he was not admitted in the state of Nebraska, because he was also trying to limit his representation, and he did in that same document, to say, I won't be doing any litigation for you. He, in his mind, and your honors, I understand that this is not the way the ethics laws actually work. But I can tell you, because I do a lot of work in the intellectual property area, there are a lot of attorneys who practice federal trademark and patent law who think that as long as they're doing that, they don't have to worry about where they are admitted in which state. There was, of course, that famous Supreme Court case where the US Supreme Court said, patent lawyers, if you're practicing patent law and admitted to the patent bar, that's okay. But that case has really caused a lot of confusion, because there are a lot of attorneys walking around thinking, as long as I am practicing federal employment law or federal trademark law or federal ERISA law, I don't need a license in this state. That's wrong. But that's what was in my client's mind when he was writing this retainer agreement, and why he was trying to be very accurate
But
about.
it's not, I don't understand you just said a minute ago that both he and his client knew that it was a false statement.
Right, and I didn't get to the punchline.
Okay.
But the punchline was, he told her, so I won't be doing anything until I get my admission from the Federal District Court of Nebraska. And indeed, that's what happened. He did nothing on behalf of the person we refer to as SD until he was admitted in the Nebraska Federal District Court.
So you're saying it was essentially a preemptory statement of an anticipated fact. Is that a
Yes,
fair
Your
way to
Honor.
say it?
Yes.
Okay.
I see my time is starting to run down. I think I've contextualized the elements that I wanted to put into context. If there are any questions from the court, I'll take them, but otherwise I'd be happy to give you a minute and 20 seconds back.
But what's his plan going forward? I mean, part of what we have to do is look ahead and to make sure that public is protected. So I think we need a little more context there.
Yes, Your Honor. Well, we've worked hard to find some helpers who will be involved with Mr. Jahn during his period of probation. One of them is Samantha Shepard, who is a very experienced elder law trust and estates lawyer in Kansas. She's has her own law firm. There are several other attorneys there. She's going to be his probation monitor. And then there's Mr. Smith, who's going to be his attorney mentor that was made available through COLAP. Mr. Jahn has not yet decided what his future path in legal practice is going to be. But I think, and I see I just ran out of time. Can I have a, thank you. But I think one thing he has learned from this very difficult situation that he's been through is that he needs to be much more careful about the clients he works with, specifically that there is additional dangers when you work with a client who you're very close with. It's hard enough working for a client because you do develop a relationship with your client and you want to do, you want to please them. You do. You want to do what's right by them. But it's more difficult when you have a personal relationship. But I also think that Mr. Jahn has recognized the importance of mentorship and will look for that. I do think if he goes back into the private practice of law, it'll be in the field of trust and estates and not in employment law, which was never in his mind. Mr. Jahn is an expert on Social Security rules and Social Security law, but he's not an expert on employment law at all.
Are you comfortable sharing Mr. Smith's first name?
Yes, I think it's Brian Smith. I'm sorry. Thank you, Your Honors.
Reserve 3 minutes.
Members of the court, the probation is designed to hopefully provide the respondent tools to go forward so that violations do not happen in the future. The facts supporting the different rule violations are set forth in the summary submission, primarily on pages 17 through 20. The false statements to others focuses on his 5/15 demand letter, which had a false address for the respondent, said attorney fees to date are in excess of $25,000. In that same demand letter, he talks generally about the prospects of settling and the costs of litigation and some of those different things. But the third aspect or violation of 4.1 false statement to others is the email that the respondent sent to the opposing party, the president of the private school, on July 26th, which attached a proposed settlement agreement. In that email, the respondent said to the party who was represented, attach, please find this settlement agreement that's, and implied it was a result of consultation with opposing counsel, which was not accurate. So that is the additional false statement there. It was actually unilaterally and significantly modified by the respondent. With that, I would stand available for questions, but I also want to give time back if there are not additional.
I have a quick question.
Yes.
In cases involving dishonesty, like you've just laid out, typically a 90-day suspension would be considered a light. I realize I'm speaking in the generalities, but we heard opposing counsel contextualize the stipulation, but you just kind of came up, and it strikes me as that you uncontextualized it. So as I read the stipulation, like it speaks in pretty blunt terms about making false statements and essentially committing fraud. And then I see, and we're asking for 90 days, and I can't quite make those things line up.
Your Honor, I think that a 90-day suspension is appropriate. This case this court has made very clear that you take a look at each case individually, that you personalize. That's not necessarily the words that you have used in case law, but you craft it for the specific facts.
Well, in light of that,
circumstances.
would you agree with what your opposing counsel again described as a contextualization of the stipulation?
I think there are contexts. The respondent absolutely was trying to do a favor, help. His fiance was committed to being helping her in what was very emotional.
I'm sorry, I'm interrupting you. I know, I'm sorry about that, but it strikes me that, and we have this, I at least have this problem oftentimes when we have these discipline cases where it seems like folks want it both ways. Like it can't be that he both committed fraud in an attempt to extort money in violation of the rules. And it was kind of an accident. He was trying to do people a favor. Like both those things can't be true. So I'm just trying to drill down to say what's the real story.
I guess for some case law context support, this court has looked at attorney disciplinary cases where there have been conduct involving knowing, intentional dishonesty, fraud, deceit. In Betts, which is 289 Kansas 820 2009, intentionally created altered an insurance card to appease his wife. In that case, I believe, resulted in a public censure. And this court has also very much, with respect in the Stockwell case, talked about how it's you can't really supervise the fraud, dishonesty conduct, but has also recognized, I believe it was in the matter of Knopp, KNOPP case, where the court appreciated that the misrepresentations are not all created equal, and some turn out to be more or less consequential depending upon the surrounding circumstances. And in the Kopp case, they imposed a 90-day suspension. They actually stayed that suspension and imposed discipline. In this case, the parties are asking this court to impose a discipline, implement 30 days of it, stay 30 days, place him on probation.
Did you mean 3 months and 3 months?
I'm sorry. Yes, I apologize. I misspoke
That's right.
terribly there. 3 was in my mind. It's, yes, 3 months. I'm so sorry.
Oh,
I have a question, if I may, Chief. Did respondent ever directly say to the president, who was represented by opposing counsel, did he ever directly say this has been agreed to by opposing counsel? Or did he just present it stating that they had talked about it?
I'm looking for my your attorney and I have been in consultation about a settlement between the school and the client pertaining to her employment discrimination suit. The document releasing the school is attached to this email. Please sign the document and send it back to me so I can pass it on to my client. And that is in volume 2, Bates stamp page 59. So it was implied that the attached document is a result of the consultation between the two attorneys, which it absolutely was not. A draft had been sent to the respondent. That draft by opposing counsel was significantly modified, unilaterally modified. The respondent didn't return it to opposing counsel. In fact, he'd had an email communication shortly before then indicating that, yes, he had some thoughts about the draft. He was busy, needed a few days, and he would get back with his thoughts on it. But instead of getting back to the opposing counsel, he sent it to the represented party.
was there some evidence in the record that it was not actually him that sent it to the president of the school, but that?
So the evidence in the record reflects that the respondent and his fiance were sharing an address. And there is, I believe, an affidavit from the fiance that says that she was there with him when he sent it. And she believed it to be appropriate. I'm paraphrasing a little bit there, but the evidence has been that he sent it to the school president. I want to call it principal, but it's president.
Clifford, do you have an objection?
Justice Dandridge, right, he never explicitly said, this is the agreement that was sent to us and we're signing it just as it is. And Justice Daigle, there was no money for anybody in the settlement agreement. The truth is, the changes that were made, and it's in an affidavit that was filed with the panel. Respondent's fiance was in a very fraught and highly emotional state at the time that all of this occurred. And respondent did not want her to change that agreement. That's also in the record. It was actually, and I have to say specifically, my client has taken responsibility. He's not saying, oh, she did it, not my fault. But it was respondent's fiance that made these changes and then asked respondent to send the agreement. If he had said, I'm not touching this, and she had sent it, we wouldn't be here right now. But he sent this agreement. There was no money in this for him. So the mitigation here is that it was an extremely fraught, emotional situation, to the extent that my client was concerned about his fiance and her well-being. Again, that's not an excuse, it's a context, and that's all I wanted to add.
Clifford, anything else?
Only if there are questions.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take the case under advisement.